What about?
Because I know there's a case in Czechoslovakia that a rapist was, serial rapist was chemically castrated, but it's reversible.
But it's reversible. But this was not an issue where there was any midway zone. Let's put it that way. But yeah.
You might add, this was, I think, in the context of eugenics as well, right? The idea was you castrate criminals because you thought they produced the criminal class, right?
In the Skinner case, there's no question about it. And Skinner is, of course, seen as one of the major departures from the Buck versus Bell and the eugenics line of cases. But it's certainly not a right to marry case. So, kind of promoting the combination of the two. So what the California court ends up stating, though, in Perez, is characterizing the right to marry as the right to join in marriage with the person of one's choice. That it's the core element, the essential element of choice and consent that is really operative in Perez. Much more so, actually, than in the U.S. Supreme Court discussions of the right to marry. It isn't that the concept or the principle of individual choice is overlooked in the U.S. Supreme Court decisions, but it actually is given a centrality in Perez that is not present in a lot of the cases at the U.S. Supreme Court level that deal with the marriage issue. Well, at the time, Perez got almost no attention whatsoever. And it's really going to be nearly 20 years before that arrest of the Lovings in Virginia then culminates in the willingness of the ACLU and the NAA Legal Defense Fund to take on this issue of the anti-miscegenation laws in the 60s. But again, not until the right to vote, the right to attend integrated schools, and the right to be free from discrimination in employment was supposedly well established by a series of laws in the 50s and 60s. So here are the Perez, still happily married in 1990, and moving along to a famous picture of Mildred and Richard Loving in 1967. The two happy couples, how do they resonate with some of the more contemporary controversy about access to marriage for same-sex couples? I think that if you looked at some of this account of the testimony at the trial in the challenge in federal court to Proposition 8, the trial that took place in January of 2010, Helen Zia's testimony, if you had looked at or had listened to any of the other testimony from the plaintiffs themselves and from a lot of other kind of plain folks, you would have seen an authentic and genuine but also very self-conscious effort to position these people and to position the case in a long history of happy unions of adults freely choosing each other, desiring to have not only their private mutual commitment to each other, but strongly desiring to have that commitment to each other recognized and approved and acknowledged, accepted and broadcast by the state to the rest of the world. And indeed, arguably, one of the major reasons for the failure of the no on Proposition 8 folks to prevail in the referendum election of November 2008 may have been the terrible advertising campaign that the proponents of marriage for same-sex couples put forth. Why do I say terrible? because it played upon the narrowest version of the civil rights story. It played upon the version of civil rights for blacks in America, noble history, the right to vote, the right to attend schools, the right to ride in anywhere you want on the bus, the right to drink at any water fountain of your choice. It did not portray the people, the couples, the families, the extended families who were so involved in this kind of romance and commitment to the notion and the concept of marriage in the United States. And one of the lessons, I think, from the Prop 8 campaign and the very upsetting victory for the people who promote exclusion from marriage is that in the Walker trial, the performative aspects of the whole trial are extraordinary, but most extraordinary was the way in which the narrative of love, commitment, acceptance, recognition, belonging was told. That narrative was developed and told over and over again. And that, of course, is, from many perspectives, a quite conservative narrative. It's a narrative of belonging and a desire to belong to an institution that is heavily laden with history and tradition, at least in the past, a history and tradition not only of exclusion of same-sex couples, but of exclusion of interracial couples, and an institution that mandated within its confines a patriarchal, sort of top-down, man in control, husband in control of wife and the dependents view of the relationship. So there are many ironies in this tale, but I think ultimately one of the ultimately successful moves on the part of the advocates for allowing marriage for same-sex couples is to begin to play into the kind of loving relationship you see between the Lovings, and before that, the Perezes in that photo of them. So then, of course, what you get in Loving, which is primarily an equal protection decision. It's a decision, a unanimous decision by the U.S. Supreme Court, declaring that on its face, the exclusion from marriage for interracial couples is obnoxious, it's invidious, it's intolerable, unacceptable, and that it is so obnoxious and invidious that it is not possible to envision a justification. So that what until 1967 had been the widely assumed right of the states to continue to prohibit whites or Caucasians from marrying the other is all of a sudden, across the board, declared to be such an obnoxious notion that it can't withstand any scrutiny under the Equal Protection Clause. And primarily, Loving is not about marriage. 99% of the decision is about how invidious racial distinctions are now put into the context of marital relationships. And almost as an afterthought, in a final paragraph or two, with hardly any authority being cited, the court announces that in addition to the equal protection issue, the Lovings have been deprived of liberty without due process of law in violation of the Due Process Clause of the 14th Amendment. Freedom to marry, long recognized as a vital personal right, essential to the orderly pursuit of happiness by free men. Now, I have a lot of dots there, not because I've eliminated 12 to 15 citations. There's hardly any citation, except to Skinner from 43. The freedom to marry or not marry a person of another race resides with the individual and cannot be infringed by the state. So here we have a kind of birth or announcement at the U.S. Supreme Court level that there is some kind of liberty interest, something intangible but nonetheless present that can be felt, and that it is part of the package that individuals carry around with them in the United States that deserves protection against certain state deprivations. Here, the deprivation would be the limitation on your choice of a marital partner. But this is also language that obviously could go in a whole bunch of different directions, and is not language that automatically lends itself to extending beyond opposite-sex couples to people of the same sex or the same sexual orientation, of the same gender, seeking to enter this relationship. The only other times when the court directly dealt with a marriage restriction are two cases in the late 70s and 80s, Zablocki and Turner versus Safley. In the Turner decision, the question of what is the right of marriage that the court was going to protect, in Zablocki, is addressed in almost 9 different ways. There are 9 people on the Supreme Court. There were at least 7 different opinions in the majority or in the dissent. And mostly, the plurality seemed to be on the side of recognizing and deferring to state regulation of the marital relationship, except when some extreme infringement occurred on the individual right to enter into this relationship. And Zablocki itself, it was a child support case. The state of Wisconsin was trying to collect child support, mainly from fathers who had children out of wedlock who were not paying child support, including impoverished fathers who couldn't pay child support, but whether they were trying to or not. Wisconsin said you can't get married in the state of Wisconsin unless you prove to us that you're supporting your children. In a sense, Wisconsin was trying to condition marriage on responsible procreation, and even though they wouldn't have put it quite that way. But the Supreme Court, even though their opinions are all over the place, decided that no, this is not a legitimate reason to prevent people from exercising their right to marry. So kind of all the deadbeat dads can get married and have yet more children within the marital relationship. But it's a very confusing opinion. It's also one in which the then Justice Powell writes a very eloquent defense and an expansion upon this concept of a due process right, a fundamental liberty interest